Hello, friends. Welcome to, I think I'm unmuted. Welcome to Rights Revoked, a roundtable discussion sponsored by ACMRS in the wake of the Dobbs decision to provide a forum for historically informed insights about reproductive justice. My name is Kim Hall, and on behalf of the panelists, I'd like to thank ACMRS and Ruben Espinosa for the invitation to participate in this discussion, as well as M. McDonald and Leah Newsom, who brought us together and who have been herding cats behind the scenes. Today, I'm speaking to you from Lenape-Hoking, the homeland of the Lenape people who were genocided and chased from their ancestral land centuries ago. In the context of this discussion, it seems significant to point out that globally, Indigenous women experience worse maternal health outcomes than non-Indigenous women, and that a significant part of colonial practice is legal and cultural attacks on Indigenous knowledges and practices, such as Indigenous midwifery. This panel was conceived in the spirit of a reproductive justice framework, and I wanted to give a very short background on that term. From the words of activist Loretta Ross, in the tradition of the Combahee River Collective, 12 Black women working within and outside the pro-choice movement in 1994 coined the term reproductive justice to, quote, recognize the commonality of our experiences and from this sharing and growing consciousness to a politics that will change our lives and inevitably end our oppression. As the Women of African Descent for Reproductive Justice, this group pushed back against a reproductive politics dominated by the concerns of white middle-class feminism. They published open letters to Congress calling for an intersectional approach to women's health care. Linking reproductive health to a human rights framework, they asserted that reproductive freedom is a life and death issue for many Black women and deserves as much recognition as any other freedom. They demanded anti-discriminatory provisions to ensure the protection of all women of color, the elderly, the poor, and those with disabilities. And they demanded that healthcare not discriminate on the basis of sexual orientation. Thus, their practice encompasses much that is not included in a U.S. rights framework, the health and safety of individuals, families, and communities. So today we have short papers by Ariane Balizet, Maeve Callan, Lydia Harris, and Valerie Traub, scholars of the medieval and early modern eras who have long been doing important work in women's histories, gender, race, and sexuality from historical perspectives. They've agreed to dispense with their impressive biographies, which you can find on our event page and linked in the chat. They will be presenting their papers in alphabetical order. We encourage you to use the Zoom Q&A function to ask questions of the speakers or of the panel as a whole. So now I'm going to turn it over to Ariane.
Thank you. I am honored to be in the company of these esteemed presenters and moderator. And I'd also like to thank everyone at ACMRS, especially Ruben Espinosa, M. McDonough, and Leah Newsom for welcoming me to this conversation. Shortly after Roe v. Wade was overturned, I was lamenting the decision with a white woman I love and admire. While she described her fear of a dystopian future, I was consumed by visions of an impossibly painful past. Black, brown, and Indigenous persons have endured generations of reproductive injustice, including forced birth, forced sterilization, and systematic separation of children from their parents for ineffably cruel exploitation and violence. In our post-Roe world, however, fictional white handmaidens seem to provoke more outrage than the very real histories of Black, brown, and Indigenous women, girls, and persons of marginalized genders. I am sure that many of you have had similar exchanges over the past month. You may have, like I did, employed your scholarly expertise to reframe the conversation in terms of historical injustice. You may have, like I did, felt the weight of that injustice in your bones. I am the daughter of a Puerto Rican mother with Black skin. Puerto Rico was the site of early trials for the birth control pill in the 1950s, and by most accounts, the island of Puerto Rico was chosen for these trials in part because of its poverty and overcrowding, and in part because surgical sterilization was legal and widespread, thanks to clinics funded by eugenicist Clarence Gamble. In the 1970s, Black, Indigenous, Mexican, and Puerto Rican women were commonly targeted for sterilization campaigns, while white women faced increased restrictions on access to permanent birth control, revealing the racist logic beneath much of the 20th century's advancements in reproductive health care. The primacy of the right not to have a child in conversations about reproductive justice over the right to have a child and parent one's own children shores up the racist logic manifest in widespread efforts to maximize white women's reproductive capacity while, quote, controlling Black, Brown, and Indigenous population growth and separating children of color from their families and communities. Raised in Bayamón in the 1940s and 50s, my mother witnessed much of this history and its impact on her family. Her upbringing also included an education in 16th century fictions of the Caribbean that remain part of her identity and lived experience, fictions that she and I better understood as such when I began this research. My mother was taught, for example, that neighboring islands were populated by the descendants of the anthropophagi. When I was a child, her use of the Latin term always struck me as historical proof of what I now understand to be a lie. In The Historian is Curandera, Aurora Levins Morales notes, part of the task of curandera historian is diagnosis. We need to ask ourselves what aspects of imperial history do the most harm and which lies are at the foundations of our colonized sense of the culture. These lies from the past continue to shape modernity and modern identities, including my own. My interest in the colonial lies and reproductive injustices on one particular island in the Caribbean informs my reading of the imaginary island of Shakespeare's Tempest. The play dramatizes conflict over all three core principles of reproductive justice: the right to not have a child, the right to have a child, and the right to parent in a safe and healthy environment. In the Act 2 debate over the marriage of the king's fair daughter, Claribel, to the king of Tunis, Sebastian decries his brother for squandering Claribel's fairness by marrying her to an African and not a European husband. By orchestrating his daughter's marriage to the Prince of Naples, however, Prospero earns the promise of fair issue. Miranda's capacity to bear white children is upheld as a political victory for the restored Duke of Milan, whereas Claribel's capacity to bear mixed-race children is viewed as the King of Naples' final defeat. In retelling the story of Caliban's attempted rape of Miranda, Prospero upholds his daughter's right to not people the Isle with Calibans, although, of course, he is most concerned with her honor, which is his honor, not her rights. And the story of Sycorax, whose pregnancy ostensibly protected her from execution, painfully illustrates the injustice of a mother forced to give birth alone and in exile, ultimately separated from her child by death. It is not coincidence that a play concerned with colonial competition and European supremacy over an island that vividly evokes the West Indies should depict so many instances of reproductive injustice. As scholars of early modern literature and culture, we must understand the fictional worlds of Renaissance drama within the context of historical suffering and the dystopian present forged by colonial lies. Thank you.
Thank you so much. I'm going to turn to Maeve Callan.
Leah, I'm not able to share my screen yet. But as we wait, I'd just like to thank Dr. Balizet for that wonderful talk and to echo the expressions of gratitude to everybody who's helped organize this vitally important event and is attending it right now. So hopefully you can see that. Okay. Abortion is healthcare and a basic bodily right of anyone with the capacity to get pregnant. In a secular democracy, especially one with rich religious diversity like the United States, the only religious views that should determine if an abortion occurs are those of the person whose pregnancy it is. But since the myth that religion, and especially Christianity, unequivocally condemns abortion has caused the revoking of this basic bodily right in our country, it needs to be recognized as the dangerous distortion that it is. Multiple surveys attest that both religious and non-religious Americans strongly favor legal abortion. According to a Public Religion Research Institute survey conducted 6 weeks ago, 65% of Americans say abortion should be legal in most or all cases. Among different religious affiliations, white evangelical Protestants are significant outliers, with 1 in 4 saying abortion should be legal in most or all cases. By contrast, 64% of white Catholics, 69% of white mainline Protestants, 75% of Black Protestants, 75% of Hispanic Catholics, 82% of non-Christian religious Americans, and 84% of religiously unaffiliated Americans support abortion legality in most or all cases. In an analysis of American Catholics published in May, Pew Research Center found that 56% favor abortions being legal in all or most cases, and 42% oppose. That same study found that 44% maintain that life begins at conception, a view that generally regards the fetus as a person and abortion at any stage as murder. Yet such a claim, which many now see as essential to Catholic identity, became dominant only about 150 years ago, in contrast to centuries of Catholic teachings that a fetus became a person weeks, if not months later, once it receives a rational soul. This often gets associated with quickening, when the mother feels the fetus move for the first time, generally in the 5th month of pregnancy. Some of Catholicism's most vaunted heroes held this view of human development and explicitly distinguished abortion from homicide, including Augustine and Aquinas. This position was echoed by popes and ecclesiastical councils, including Innocent III in 1211 and the Council of Vienne a century later. Abortion was seen as a sin, of course, in keeping with general medieval attitudes about sexuality, aptly illustrated in James Brundage's handy chart summarizing penitentialists' teaching about when sex might be illicit, which essentially would be a Monday, Tuesday, or Thursday night, but when you're clothed and without caresses, kisses, or pleasure. To the penitentialists, pretty much everything was sin, the severity of which can be measured by the penance it entails. In the Irish canons, the penance of a woman who has had an abortion amounts to a quarter or half the time of the penance of a man who has committed fornication. In the Old Irish penitential, the penance depends on the stage of pregnancy, divided into 3, like trimesters. In the first, 3.5 years of penance. In the second, 7 years. In the third, 14 years, the same of homicide. The penitential of Finian takes an even more permissive attitude toward abortion. His female reproductive penances seem aimed at nuns, though he simply refers to a woman. If she has an abortion, she is to fast on bread and water for 6 months and refrain from wine and meat for 2 years. Quote, but if she bears a child and her sin is manifest, she shall do penance for 6 years, as is the judgment in the case of a cleric. And in the 7th year, she shall be joined to the altar, and then we say her crown can be restored, and she may don a white robe and be pronounced a virgin, end quote. Presumably, this restored virginity after 6 years of penance for childbirth applied specifically to nuns, not laywomen. Finian treats religious men's sexual and reproductive sins much more severely. A cleric who has sex only once and covertly has to fast on bread and water for twice as long as a woman who has had an abortion. If it's habitual, it's 6 times as long. A cleric who begets a child and commits infanticide must fast for 3 years on bread and water, followed by 3 years without wine and meat for 2/3 of each year and 1/3 on bread and water, as well as be exiled for 7 years. Finian adds, if, however, he has not killed the child, the sin is less, but the penance is the same. For abortion, the sin must have been significantly less, as the penance was nowhere near the same. The biographies of at least 4 medieval Irish saints, including beloved Bridget of Kildare, celebrate abortion among their miracles. The most detailed account is told of Kieran of Sayre, after he rescued a nun who had been abducted by a local king. Quote, when the man of God returned to the monastery with the girl, she confessed that she was pregnant. Then the man of God, led by the zeal of justice, not wishing the serpent's seed to quicken, pressed down on her womb with the sign of the cross and forced her womb to be emptied. End quote. The reference to quickening presumably indicates that the abortion occurred during the first 4 months, but none of the miracles specify the stage of pregnancy. According to the late June PRI survey, 33% of Americans think abortion should be legal in all cases, while 8% say it should be illegal in all cases. But a Pew survey from March shows that support shifts with stage of pregnancy. Almost twice as many Americans support legal abortion at 6 weeks as oppose it, at 51% to 26%. At 14 weeks, or the start of the second trimester, the gap shrinks, with 41% supporting and 33% opposed. At 24 weeks, those opposed outnumber those in favor. 48% say it should be illegal and 29% legal in all or most cases. Over 90% of abortions in the United States occur during the first trimester, and only 1% occur at 21 weeks or later. This gradated approach to abortion better accords with dominant Catholic teachings until the late 19th century than do those that insist that abortion at any stage is murder. The white evangelical shift to seeing abortion as murder is even more recent. As Randall Balmer argues, it arose after the 1978 midterm elections, 5 years after Roe versus Wade, when anti-abortion Catholic voters enabled anti-choice Republicans to defeat favored Democratic candidates in New Hampshire, Iowa, and Minnesota. And leaders of the nascent religious right realized they could exploit abortion as a populist issue to further their true core cause, protecting the tax-exempt status of whites-only evangelical schools. So, racism. Fascinating as this all may be, however, it doesn't change the fact that abortion is healthcare, and in a secular democracy, no one's religious views but the pregnant person should be decisive. Thank you.
Keep forgetting me on mute. Thank you so much, Maeve. We're going to have Lydia Harris next.
Thank you very, very much. I think Maeve and I's talks kind of go along very similar lines in terms of the religious and the medieval, so I think it's quite a nice segue. I'd just like to echo the thanks of all the other panelists as well to the members of ACMRS for obviously organizing this and having us here, and obviously Professor Hall as well for moderating this. So, one of the things that struck me when reading the Supreme Court decision in Dodds versus Jackson was the use of medieval law to justify the so-called, and I quote, 700 years of Anglo-American law. The ruling cites Henry de Braxton's mid-13th century treatise, which criminalized abortion after quickening at approximately 17 to 22 weeks of pregnancy, depending on what pregnancy it is, as evidence that medieval English law was overwhelmingly anti-abortion. But this is giving a rather simple and adaptable explanation to something that was a bit more complicated. The code to which Justice Alito refers is from a particular passage by Henry de Bracton, who lived circa 1210 to 1268, from the De Legibus et Constitutionibus Angliae. The passage reads, if one strikes a pregnant woman or gives her poison in order to procure an abortion, if the fetus is already formed or quickened, especially if it is quickened, he commits homicide. Although it is correct that this does define abortion as a criminal activity, Alito does admit that what this law describes is abortion by assault and abortion by deception, and the blame is placed on those third-party figures who caused the woman to abort her child rather than placing the blame on the pregnant woman herself. Now, de Bracton's treatise also emphasizes another common factor in medieval law regarding abortion, which held that abortion was only committed if the mother had been capable of feeling the fetus move, thus inadvertently insinuating that there is a specific gestational time in which abortion became criminal. This exception to the rule for those fetuses who had not yet quickened provides evidence that early term abortions, and indeed fertility control of any type, was extremely difficult to prosecute without confirmation of pregnancy. Indeed, any evidence for criminal prosecution may have only been known by the mother before her second trimester at the earliest. The Pregnan's treatise also causes us to question the medieval view of pregnancy and indeed of the accepted distinctions between embryo to fetus and therefore fetus to child. Even when criminalized, the killing of a fetus is still only seen as illegal if it happened after quickening and thus when ensoulment was thought to occur, thus necessitating de Bractem to specify that the fetus should be already formed for this action to become illegal, in the Latin, iam formatus. Even within canonical statements on the nature of abortion, a quickened fetus incurred different charges in the infliction of death upon a pre-quickened fetus. In 1211, for example, Innocent III wrote to a prior of the Carthusians after a monk was found to have caused abortive assault on a woman. The letter writes, "We have learned from your letter that a certain priest of your order, who previously had been a black monk, playfully grabbed by the girdle a certain pregnant woman with whom he had been bonded together in an indecent intimacy, and who had asserted that she was carrying his child. As a result of this grabbing, she claimed to have been injured, consequently suffering an abortion. For this reason, the priest, on the advice of prudent men, decided to refrain from ministry on the altar. But we are responding to you by the present letter that if the fetus was not yet animated, he can minister. Otherwise, he ought to abstain from duty on the altar." The distinction between the killing of a viable fetus and thus being barred from his religious duties at the altar versus an early term miscarriage create a striking stance on attitudes towards violent abortions from the medieval church. As a priest, his indiscretion and physical mistreatment of the woman were punished, not according to the status or the health of the woman, but by the quickening of her unborn child. In addition to these gestational distinctions concerning ensoulment, very little mention was made in high medieval legal records, which actually offered appropriate punishment for the mother who initiated the termination of her own pregnancy. Overwhelmingly, the pregnant woman was portrayed as a passive figure, merely the victim rather than the instigator of abortion in legal text. The father of the unborn child was just as frequently mentioned, if not more so, than the mother. Rather than speaking of morality, his loss of a child was mostly seen as a fiscal problem, robbing him of the stability that an heir could provide or the chance to incur more financial gains through additional labor. As a father, the terminated pregnancy could complicate inheritances or curtail his supply of laborers. And as a lawmaker, the loss of a child was one less taxpayer, soldier, farmer, or childbearer for the future realm. Despite these financial and social disadvantages, there is ample evidence to suggest that the unexpected loss of a child was met with a comparable level of emotional stress from the parents as it would in the modern period. So, like today, pregnancy was an emotionally invested state. The vast majority of medieval parents, contrary to some assertions, clearly cared for their children. In this sense, the loss of a pregnancy had financial as well as spiritual and emotional implications. Although the church and penitential texts outline the necessary atonement required after abortive incidences, civil law tended to criminalize abortion in monetary rather than penitential ways. Additionally, those who killed their fetuses before detectable movement faced less severe punishment than those who did so after quickening, indicating that not all terminations were equally penalized. If the pregnant woman died from the violence of an assaultive miscarriage, there was no question, however, that it was a homicide. But if she were to commit an abortion on her own body in secret, there was very little evidence for indicting her as a murderer. Despite Justice Alito's remarks, except for a few notable cases brought against women for the death of infants, most instances of medieval abortion were left unprosecuted. The criminal prosecution of abortion only really started to appear in court records in the 13th, 14th centuries, and then sparingly. One exception obviously did exist, however, as abortion by assault was always included as a criminal offense and frequently mentioned in high medieval legal codes. Legal attitudes towards abortion by assault are usually the only mentions of criminal action against the fetus. Even then, it is usually criminalized for the dangers inflicted upon the mother, or the financial damage the loss of an heir could place upon the father. In this sense, it is misleading to insert medieval law into modern American constitutional justice, as it isn't a one-size-fits-all categorization for modern legality. If anything, it just leads to more questions, particularly, why in the world should 13th century English code have any bearing on 21st century American law? Thank you.
Thank you so much, Lydia. Before we move on to our last paper, I just wanted to remind our viewers that they're welcome to put questions in the Q&A section, and we will now go to Valerie Traub.
Thanks, Kim, and thanks to ACMRS for the invitation to join. It was really heartening to receive the invitation so soon after the Supreme Court decision came down. And also, I just want to thank my fellow panelists. Those were great talks. My remarks dovetail with much of what has been said, but I'm going to focus on strategies for the pre-modern classroom. So when I read the Dobbs decision, I was struck by the centrality of history in the majority opinion. Again and again, Justice Alito opines that, quote, a right to abortion is not deeply rooted in the nation's history and traditions. Rather, he says, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. Alito depends primarily on Joseph Della Penna's 2006 book, Dispelling the Myths of Abortion History, which argues that, quote, abortion was considered a serious crime throughout most of European history. Now, numerous historians and today's panelists have shown that pregnancy termination prior to quickening was a little concern to either English or American law before the 1820s, and that common law allowed extensive decision-making by the pregnant woman. My first pedagogical suggestion is to assign students the Dobbs decision's early modern evidence, consisting of a single criminal case of 1652, relevant citations from Della Penna's book, excerpts from Carla Spivak's critique of Della Penna's work and her analysis of the early modern English cultural context, which concurs with what Maeve and Lydia have spoken about, a Washington Post op-ed of July 19, 2022, on a 1792 American case in which charges were not brought against a woman who self-induced an abortion in the second trimester, which was a fascinating case, and parts of the amicus brief by the American Historical Association and the Organization of American Historians, which summarizes changes in American legal practice. Based on these materials, I would ask students to discuss what history means in this context. Which history, which historians, and whose history is being used to define our national history and tradition. Having introduced the need to subject contending histories to scrutiny, I would move from the realm of the law to center women's bodily experiences. We would begin with the notion of quickening to explore the temporality of decision-making, including the difficulty of knowing if one is pregnant or menstruation merely late, and how this experiential criterion paradoxically fostered women's reproductive control. I would then turn to the pharmacopoeia described in manuscript household remedy books, printed recipe books, herbals, and midwifery and gynecology manuals to regulate menstruation. In my own garden, I have many of the herbs most often mentioned to hinder conception or bring on the flowers. And here is a bouquet of them. The demise of women's herbal knowledge occurred only after male doctors had wrested gynecology away from midwives, which set the stage for the 19th century criminalization of abortion. Shifting from jurisprudence to women's reproductive planning would invite discussion not only of these two historical shifts, but of women's reckoning of their disparate circumstances, including poverty, domestic violence, and enforced servitude. That controlling fertility is deeply embedded in the history and traditions of women in the Americas is evidenced not only by colonial white women's use of such herbs, but of Native women's practices. Knowledge of how to bring on menstruation after it had been suppressed was also possessed by enslaved women in the Americas, who faced reproductive injustice on a massive, systematic scale. Building on the fact that U.S. racial slavery was economically underwritten by the exploitation of slave women's sexual bodies and reproductive capacities, my next strategy would be to assign passages from travel narratives and naturalist accounts that report that African and Native women were using herbs to abort their children to prevent enforced servitude. One could link these women's impossible situations to the trial of Margaret Garner, who killed her daughter to prevent her enslavement, and Toni Morrison's fictionalization of Garner's story in Beloved. This would provide an opportunity for early modernists to connect such women's acts of resistance to the advent of the 13th and 14th Amendments and to the novel strategies now emerging to contest the Dobbs decision by means of their protections of Black people. Several pieces of imaginative literature, Shakespeare's Rape of Lucrece and Ben Jonson's Epicene among them, provide productive prompts for discussion of the contours of reproductive justice and injustice. I will end by recommending two less familiar ones. Some of you may know the Ovidian tale of Callisto, who is raped by Jove after he assumed the shape of Diana. In a translation of the medieval French Ovid Moralisé, Callisto's shame, pregnancy, birth of a son, and transformation into a constellation are followed by moralistic commentary about, quote, women who spend a good part of their lives whoring around. And then the text continues, quote, although it be against nature, against justice, against mercy, some women, all the better to conceal their wickedness, use potions to make the semen perish in their bodies or to compress and kill it at birth. O God, what awful treachery and horrid cruelty it is when those who are completely guiltless are given over to eternal death and condemned by their own mothers, often before they are even born. Now the link between Callisto, who carries her pregnancy to term and does not kill her son, and those whores who abort or kill their infants is never revealed. This lacuna in patriarchal logic raises the issue of how responsibility for unwanted pregnancy falls not on rapists, but on survivors. Exploring this logic might enable students to connect the centuries-long history of anti-feminism to the Supreme Court's cloaking of its anti-feminism as impartial judicial reasoning, including Alito's claim that, quote, a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. Paired with the English infanticide statute of 1624, the Callisto story could lead to discussions of the fact that, as numerous historians acknowledge, from the beginning concerns about abortion were part of a broader concern with illicit sex, and that when infanticide was criminalized in England in 1624, it was the sexual conduct of indigent, unmarried women, rather than the life of the infant, that was of primary concern. Another opportunity to discuss the politics of accountability is offered by the anonymous 16th century Scots ballad, Mary Hamilton, which narrates the tale of an attendant to the Queen of Scots who becomes pregnant by the Stuart king. Mary relates that she is being summoned to be executed because, having secretly given birth, she put her infant son in a small boat and pushed him out to sea. In one version, the king, seeing Mary enter the town for her execution, invites her to dine with him. She retorts, in a stunning rebuke to her monarch and to the double standard, quote, hold your tongue, my sovereign liege, and let your folly be. And ye had a mind to save my life, ye should not have shamed me here. Learning that such acts of resistance are part of our history and our traditions could provide students with some support for the long struggle ahead. Thank you.
Thank you so much, Valerie, and thank you to all the panelists. You did amazing work in an incredibly short period of time. We don't yet have questions in the chat, in the Q&A, so I'm just going to start off with, a very broad question, and it seemed kind of a stupid thing to notice, but the full title of that Dobbs decision has health in it 3 times. The state health officer of the Mississippi Department of Health versus the Jackson Women's Health Organization. So I'm wondering if you could all say more about the various ways health and healing play out in your papers or in your scholarly work more generally. And I'm going to specifically ask Ariane if she could say a bit more about the curandera historian, which I think you're posing for us as a model for ethical and interpretive and historical practice. So I wonder if you could start off telling us a little bit more about that modality, and then maybe the other panelists can talk about where health and healing fits into their work.
Sure. It is convenient, isn't it, that term and that concept dovetails so nicely with this broader horizon of both facetiously and also sincerely talking about what healthcare is and what kinds of healthcare are rights. So one of the things that strikes me as exciting about Morales's work has to do with the notion that medicinal history is possible, that there is, through the diagnosis, through the uncovering of certain aspects of history, through the re-storytelling of hidden histories, and then I think most provocatively through the exposing of certain kinds of lies and just pointing them out as such, that there is a form of healing, of course, for the historian, and I think I would probably say in my own experience for the historian's family, but also for the readers and for the students or for colleagues and other scholars. And I think what has been most powerful for me is to really find a sense of freedom and ease in recognizing the lie and recognizing all of these lies, that I think, all of the papers that were shared today have brought up moments of real insincerity about who deserves to be cared for and who deserves to be healthy, who deserves to thrive. And I think just, this sort of experience of recognizing something as a lie and applying one's energy to exposing and examining that lie has been really exciting for me. And it's interesting because, a lot of my work, at the very, very beginning of my career had to do with healing, but it was all about healing that really just hurt people. It was about like bloodletting and, the use of emetics for absolutely everything and all kinds of different really upsetting experiences when you're already sick. And so even in this moment of real pain for all of us that are participating today, it is interesting to start thinking about how healing can actually occur, how we can apply our intellectual faculties towards some kind of collective healing.
That's really beautiful. Thank you. And I'm wondering, this is an open invitation to the other panelists to talk, if you want to, about where health and healing fits into your work, either in the classroom or in your scholarship or in your activism.
So just to sort of jump in with that. Oh, sorry. No, go ahead, Valerie. You'd like to? Oh, okay. Thank you.
Lydia, then we'll go to Valerie.
Perfect. Okay. Right. Yeah. So with the idea of healing, a lot of what I've done research-wise has also been on something called miraculous miscarriages, because it's not just about obviously the physical healing, it's also about the spiritual healing. And one thing that I almost actually talked about today, but I didn't really think it quite fit in with this, was a tale which was said to be truthful in the 12th century in England by a nun in the Gilbertine Priory of Wotton, who apparently became pregnant by a lay brother. She was apparently unsuited to the life of a nun. She was given to the church as an oblatio. So basically she was an unwanted child who then herself became pregnant. And whenever and so as this tale is recounted, as the other nuns find out about it, they basically chastise her and beat her and starve her to find out who the father is. When they find out who the father is, they force her to castrate him. And it is after that moment that she is no longer pregnant. She is revealed as miraculously cured. Her body is restored to virginity. She's restored, I think the exact wording is sempre proca. So it goes back to forever beautiful, forever young. And that this idea that healing, especially whenever it comes to reproductive healing, is not even necessarily in a physical sense. It's very much in a spiritual sense in a lot of these instances as well. That women weren't just seen as physical entities, but also as something that needed to be spiritually saved. So it's interesting whenever we look at something like the spirit, like the right to reproduction, and then we look at something in the medieval that actually, when you find these instances of these miraculous miscarriages, because it was healing in a sense, not just spiritually, but also physically, in the sense that they didn't want these women to be pregnant, that a miscarriage, that an abortion essentially is seen as something good, as something healing. To go about what Ariane said of that, bloodlettings, of all these other things, that are these incredibly horrific events, the beating of a young nun leaves her healed in a way. So just to add to that, Valerie.
I think I have 4 quick points to make in response to Kim's question. One is, despite the word health all over that title, how little concern there is for health in the Dobbs decision, particularly in the context of the discussion of undue burden. It's extraordinary. They just think anybody can do whatever they want anytime. And the dissent tries to call them out on that, but not very effectively, I would say. The second thing is that I mentioned this very briefly in my talk, but the historical sequencing of the male takeover of midwifery and gynecology and the criminalization of abortion are linked, things historically. And so the suppression, so the way in which the medical profession professionalized itself by separating itself off from women's practices, and then criminalized women's knowledge and actively suppressed women's knowledge, including of herbs. Like, I didn't know that all these things in my garden could induce an abortion or could kill semen, or, they're just flowers to me. But that is something that, several centuries ago, women did know. And John Riddle makes a really good case in Eve's Herbs of how that knowledge was actively suppressed over the course of the 18th and 19th century. And then finally, I would just say that Carla Spivak, whose article To Bring on the Flowers is wonderful, and I highly recommend it. She makes the point that I'd never really thought of, because we don't tend to think of privacy as something that women had in the early modern period or the pre-modern period. But she basically talks about how quickening is happening in the realm of privacy. And because it's only the woman knows if her fetus has moved. And so there's a way in which, paradoxically, that gave women more control. So there's a way in which we could make the link, the privacy argument, which has now been, overruled, all the way back to the early modern period.
That's amazing. Maeve, do you want to?
Yeah, I just wanted to know, building off of something that Lydia said, abortion obviously is healthcare, and that's fundamental, and it's about basic bodily autonomy, and we know they're not stopping at abortion. We know they're coming for all sorts of bodily rights of all sorts of people. But in the medieval material, it is much more about spiritual healing. And there's the idea of restored virginity, that this was a pure state. There's a story of another saint who doesn't perform a miraculous abortion, but after this nun gets pregnant and has a child, the Saint Ida, it's Sonata, which can be restored. She was restored to virginity, and she was healed. And I also want to note that these are not champions of choice in any way. Building again on what Lydia said, that the saints did not want those pregnancies. Those pregnancies were problematic to the saints. We do not hear from the women themselves, apart from the one story that's told of a female saint. We get to hear from the woman after she's undergone this experience, and it says she gave thanks to God. And we don't know what that thanks means, And one of the saints, one of the miracles, in advance, she asked the saint to bless her womb, and she's already pregnant. And his blessing aborts the fetus. And who knows what she wanted? We don't hear from these women themselves. They did not have control over their own bodies in these stories, which were all about the, generally speaking, male saints, but in one case, female saints.
Forgetting. Thank you so much. We also had a question about whether a works cited list could be put together, and Leah and M have graciously agreed to try to do that in conjunction with putting this up on YouTube. The other question was one I wanted to ask, but I couldn't figure out a good framework because it could just lead us off the cliff. So from Jamie Paris, can you say a bit more about the use of history as a bad faith legal strategy? The cases used in the decision seem to be selected to come to a particular decision rather than being an objective reading of the issue. Yet the use of history in the decision seems to deny the idea that the reader of history or their biases matter. And I wanted to add to that, when I got to Val's paper, a point about how Alito's sleight of hand by which he manages to claim abortion is not a sex-based classification. And it reminded me of Patricia Williams's discussion of the various rhetorical sleights of hand that legal reasoning uses to create authority. And she says, by which not just subject positioning is obscured, but by which agency and responsibility are hopefully befuddled. And it seems like all of your papers are trying to not just correct distortions, but try to give us tools to think about how authority is created over time and in this decision. So I'm wondering if you have kind of favorite strategies, along the lines of Val's paper, for how you address this in your teaching, in your everyday conversations. Like, what are the tools that we have to offer to kind of deconstruct some of that authority building, both kind of through a kind of bad faith use of history, as Jamie says, and in kind of other ways that you see happening in the Dobbs decision. So is that
So I'll just say one quick thing, since I said a lot about that already, which is I think the central question really is whose history? And the court's history is the history of male jurists, and nowhere is, even in dissents or in amicus briefs, is the foundational structure that is the coin of the realm challenged. That's a big fight. But it is as if the entire last 40 years of women's history and gender history and the history of medicine and the history of sexuality did not exist. So, I mean, the complete erasure of everything that we know based on scholarship. So, and then I would also just say, in terms of Jamie, I'm not sure what Jamie Paris's point is about bias. We all are biased. I'm not suggesting that we're not. But there is an aggregate history that one can collate. One can bring together the pertinent intellectual history, the pertinent case history, the practices that we've all discussed, to create a comprehensive picture. And that comprehensive picture is completely at odds with the picture that Alito proposes is the truth.
With that as well, if I could kind of, yeah, go ahead with that as well, because that's a very, very good point. The history of, yes, whose history? And that's why whenever I was reading Alito's remarks on it, whenever he said 700 years of Anglo-American history, and I just thought, okay, well, first of all, that's an incredibly problematic phrase, because America hasn't been around for 700 years, not in this sense. So that's completely wrong. But it also presupposes a very predominantly white, predominantly Christian, predominantly male-led historical analysis and judicial review, which is essentially, let's just be honest, that is the powerhouse in American politics, is white English descent or European descent men. And especially whenever you look at something like the Middle Ages, and with biases and with thinking about the idea of using history as this thing, I think sometimes it's, in kind of going on with what Valerie's talking about, the pedagogical aspect of this, is that it's very easy to look at women in the past. I think Monica Green noted it as well. We often look at it from the modern perspective, and all we can do is really feel bad for these women who are dying in childbirth, who are being flogged, who are being called whores, who are being, all this other stuff. But then you start to realize, actually, that past is very much our present as well. That because of this decision, there are going to be a lot of women who die. There are going to be a lot of women who are put in really horrible situations. So that in a way, it's not necessarily relegated to the past anymore. It is something scarily present. And then whenever I think all of our papers have really discussed the fact that abortion has always been around. Reproductive necessity has always been around. Women have always, for whatever reason, it's their own business, have wanted to cease their pregnancies or control their pregnancies. And from what we see historically, it isn't going to stop where it is at the moment, which is terrifying. I guess so with that.
I'd like to also echo that, a lot of times people will say, you can't change history. Well, we change it all the time. History is not the past, it's our interpretation of the past based on the available evidence. The available evidence prioritizes the privileged. And so we know it's incomplete in so many different ways. And it's essential that we do what we can to try to decenter the normative so we can get a sense of different perspectives. And there are a couple of pedagogies that are out there that I find particularly useful from a historian's perspective. Reacting to the past. And then I'm a religion professor and do a lot with religious diversity and case studies, especially championed by the Pluralism Project, where they're really encouraging people to see from multiple perspectives and try to put yourself in that situation as much as you can and reflect on, what would I have done in this situation? And that history is so much, and even the case studies, which are more recent history, it's a lot of chance and luck and power dynamics and not this inevitable sense of what had to have happened.
I just want to come back to or build on all of that and swing back to the question of the law. And I'm of course not a lawyer. And maybe if I hadn't had great English professors, maybe I would have become one. But so I don't know a whole lot about the law, but what I do find increasingly when I sort of, when I act as a dilettante and start poking around in there, is what I find is that all of these legal instruments are too blunt and too imprecise to really get to what is truly magnificent about this larger concept that we call human rights. The notion that there are rights that all humans have. And whenever we start ding-danging with, what this tradition of a very particular kind of judicial system has come up with as the law, you realize how insufficient that is to describe the things that we're talking about: privacy, reproduction, parenting, bodily autonomy, healthcare. These are things that, a handful of people sitting around in black robes have not figured out and do not really fully understand most of them. And I was drawn to this in part because of something I'm working on that has to do with humanity and the humanities and the notion of the colonial context for our thinking about what is human and what is humanity, and then also what those disciplines that comprise the humanities. And so I keep coming back to this notion that just to sort of advocate for our time period and our field and say that's one of the reasons we need to be paying very close attention to medieval and early modern conversations about things that ultimately come to become human rights or issues around human rights, because this is where those, the time periods that all of us here probably studied, that's where these lies begin to fester and grow. And we need to apply a lot of attention to them.
And of course, while you were speaking, we got 3 questions. I'm just going to read them all and then let you do a round robin, let you have like the last say. So I would love to hear if any of you would also be willing to comment on solidarity. I've been thinking a lot about Sarah Ahmed's work recently, which resonates so much with what many of you are bringing up as regarding research, teaching, outreach, activism. As a teacher, and then the next one, as a teacher at a small public university in the southern US, I wonder if any of the panelists have thoughts about teaching or framing discussions on this issue when the media and sometimes students dismiss or even vilify educational institutions in general and humanities education in particular as politicized by the left or as leftist propaganda. And finally, we have a comment from an actual legal scholar. One way to approach this is to think more about the thresholds of mattering in suspect categories. Judicial review, scrutiny level used to adjudicate the constitutionalism of what a government may legislate and what is unconstitutional. US judicial scrutiny is always represented as an American exceptionalist peak evolution. So what speakers might dislodge So what might speakers dislodge, rehistoricize vis-a-vis the rational basis test, which we saw in Sotomayor's dissent, versus intermediate scrutiny used for sex discrimination and rejected by Alito? So those were amazing questions, which we don't have time to do a deep dive on, but if you want to, if you know, we'll do a final kind of round robin, also in alphabetical, and you can respond to any of those questions or offer final thoughts.
All good questions, but I just want to start off by saying hi, Benjamin. I know Benjamin, and I just wanted to say that my institution, I know many institutions are really keen on critical thinking and interdisciplinarity, and I think all of the techniques and the pedagogies that Dr. Traub always offered us today, apply to both of those qualities. So I would definitely start there and just come back to critical thinking and interdisciplinarity.
And I would echo that call as well. And I would also, that's one of the reasons why I included the image of the manuscript, so that you can see we aren't making this up. Who's the activist, or who's the extremist who's trying to, derail history to their narrative? History is messy. It's not simple. It's really messy. And it's not just about what happened in the past, but when you get this very narrow view of what the past is, I'm sure you've experienced so many students when they come and they realize they were really being indoctrinated up until they get to college. And when they get to college, they get much broader education that they can apply those critical thinking skills for themselves. So when Alito is totally distorting history in this way, who's the one who's trying to pull a fast one over the United States? So when people are saying you can't be Catholic and pro-choice, and they don't know their history of how long, I mean, to say pro-choice is obviously problematic on a number of different levels, but it's just a lot more complicated. So I think, obviously everything's become politicized, even more so of late, but I think, as I'm sure you've experienced so much, that it's like the scales falling from their eyes, and they see how much that they have been just fed a particular narrative that now they can challenge more and think for themselves.
So those are really great questions. I've just been looking back on all three of those and trying to figure out, which one to address and what's the best way of doing it. So just to kind of go along with the one about, I think it was Benjamin's, about, how do you teach this? How do you talk about a subject like this that is going to be contentious? And so I work at a university in Britain, and the idea that we always think about, especially whenever students come to university, is that, they're 18 or older, they're coming in as adults. They're going to be faced with topics that maybe they don't agree with, or they're going to be faced with something that maybe makes them a little bit uncomfortable, or maybe that questions the doctrine that they've been taught their whole lives. And that's good. That's education. That I've always kind of pushed this as you might leave this classroom, you might leave after you've read this paper, you might do some of this, and you might think slightly differently than you did. That's good. That's mean that you've disseminated that information and that you've learned. So that is one of the ways that I've kind of tended to find out around that, because obviously I'm from a southern US state and I do the history of abortion, and one thing that I get asked every single time I tell somebody, oh, I do the history of abortion and contraception in the Middle Ages, is they go, did that exist then? And you think, well, oh no, women have just been having babies for centuries that they didn't want to, of course, this always existed, and so I think as well with that, with historizing things, particularly with the last question about, judicial review and scrutiny level, that, whenever we talk about the past, we're not talking about a different species, we're still talking about human beings who lived and breathed and bled and who had different needs and times. And it's, so I've always found the best thing to do is just, to reiterate that to students as much as possible, that we're not just talking about imaginary figures, we're talking about real life people.
Do we have time for me to say something or not? We're kind of over time, but okay, so I just want to quickly address the vulnerability of teachers who are approaching these topics, whether it's sexuality, abortion, race in the Americas. I've been working with the MLA on the Committee on Academic Freedom and Professional Rights and Responsibilities over the past few years. And I just want to say, I hear you. We are in an incredibly precarious situation now. And so to make suggestions is not to minimize the feelings of vulnerability and the real possibility that you will be called to account by somebody, whether on social media or your administration. That's why I started with my first pedagogical suggestion by going back to the Supreme Court opinion, having them read it, or parts of it, it's very long, having them read De La Pena's excerpts that Alito cites, having them read the critique of De La Pena, reading the case that Alito invokes, and then letting them decide what is good history. I mean, that's part of what we're trying. I think that's what critical thinking is in part, how do you make assessments of what you think is responsible scholarship? And let them be the judge. Because like Maeve, we're not making this up. This is real. But we have to, I see our role as being curators of a history that was suppressed, has been suppressed, will continue to try to be suppressed, but we are some of the only people in the privileged position who actually know anything about this. So, I feel like we have a responsibility to share it.
Thank you so much. I just wanted to add, and it's a little thing, but Emory, I believe, maybe 5 or 6 years ago, had a year of evidence where across an interdisciplinary kind of first year thing, and maybe we need to kind of start thinking about that, because you guys have just shown so brilliantly the kind of evidence, the histories and the evidence that's there, that we can help people access, and I think that might be one avenue into that, but I want to kind of thank, on behalf of all the people who can't clap for you, I just want to say this was amazing, and you guys are stars, and I really appreciate the opportunity to be in the Zoom room with you. And so thank you so much for your generosity and grace and your expertise.
Thank you all. It was great to talk with you.
Thank you. That's
Yes,
fantastic.
thank you very much.